The big story we're tracking this afternoon, a landmark verdict by the Supreme Court. It has struck down Section 66A of the Information Technology Act. The verdict upholds freedom of speech as the court ruled that the IT section was too vague and was in violation of the Constitution. Several petitions challenged the validity of the controversial section that allowed the police to arrest those who post objectionable content on the internet and could be imprisoned for up to 3 years. The petitioners had argued that the definition of Section 66A is vague and it may lead to abuse of the provision. They also argued that even genuine comments criticizing a person were being treated as offensive. The petition was filed in the aftermath of the arrest of 2 girls from Mumbai in 2012 who had objected to a statewide strike following the death of Shiv Sena patriarch Bal Thackeray. The arrest then fueled the free speech debate leading to filing of this petition. It was also alleged that the police was misusing this section. The Supreme Court in March 2013 came out with an advisory that a person accused of posting objectionable comments on social networking sites cannot be arrested without the police getting permission from senior officers of the rank of IG or DCP. But that did not stop the abuse of this provision either.
I am awaiting the judgment of the Honorable Supreme Court, and I will come with a structured response after going to the judgment, which I am told runs into 200 pages. But hereof I am only making certain tentative comments. These cases were pending before we came to power. And after we came to power, our government, led by the Prime Minister Shri Narendra Modi, took a very conscious decision that we don't support the stand of the previous government. We respect freedom of speech and expression, respect communication of ideas on social media, and we are not in favor of curtailing communication of honest dissent, opinion, disapproval or criticism on social media. And 66A of IT cannot be interpreted in any manner so as to curtail these ideas enshrined under Article 19(1) of the Constitution. And it is very important to be noted that in our new affidavit filed, apart from reiterating these new positions, on behalf of the Government of India, we had clearly conveyed that if Article 66A, Section 66A of the IT Act cannot be interpreted in consonance with Article 19(1) read with 19(2), then we don't support that interpretation at all. Our view was very clearly conveyed in writing, it is a part of record. When the hearing commenced, on our instruction, the Additional Solicitor General Sri Tushar Mehta had also conveyed a request to the bench that the government is willing to come with additional, more stringent guidelines so as to prevent abuse of Section 66A of the Act. But the Honorable Court in its wisdom said that now since we are hearing the validity of this provision, we will continue. This is how the judgment has come. Again, as I said earlier, I will convey a structured response after going to the judgment, which I must. I am awaiting the receipt of the judgment. But the Government of India's stand, quite different from the previous government, has been very clear and consistent, which I have just mentioned.
So can you just repeat that? By a comment about government had conveyed the consonance with 99 all thoda sa complex.
No, I was just saying that after we came to power, I had instructed the Additional Solicitor General, Shri Tushar Mehta, to convey to the court that we are willing to come with further stringent rules, guidelines or regulations to prevent any misuse of Section 66A of the Act. This requires some time. But the Honorable Court in its wisdom thought that since we are hearing the validity of the Act itself, let us proceed with the hearing. आज माननीय उच्चतम न्यायालय का निर्णय आया है. मैं भी माननीय उच्चतम न्यायालय के निर्णय की प्रतीक्षा कर रहा हूं, जो लगभग 200 पृष्ठों का है, और उस निर्णय के अध्ययन करने के बाद मैं औपचारिक रूप से अपनी टिप्पणी दूंगा. अभी कुछ तात्कालिक बातें बतानी जरूरी है. सुप्रीम कोर्ट में जो सारे चैलेंजेस थे पिटिशंस के, IT एक्ट के विभिन्न प्रावधानों के बारे में वो नरेंद्र मोदी जी की सरकार के आने के पहले से लंबित थे।
All right, let's get now word from Jugal Purohit, who was inside the court when that judgment was delivered. Jugal, civil society welcoming this verdict by the Supreme Court. Any observations made by the court as it pronounced this verdict?
Well, Simi, all along, you see the Supreme Court had been giving an indication to all of us in the media fraternity that it had, in fact, found several nuances, several utilities and several aspects of 66A to be too vague and, in a sense, open to the abuse as has been seen and as has been remedied in many cases by different courts at different levels. So today's verdict striking down 66A does not really come across as a surprise. The other aspect that the court was concerned about was just what happens to policing the vast cyberspace. If I'm to use the additional Solicitor General's words, the Supreme Court and as well as the petitioners are now saying that in terms of policing, sections of IPC are already there and provisions are there to actually take into account and penalize those misusing. So the section 66A of the Information Technology Act 2000 was not really required, and that's why the Supreme Court has struck it down. The Apex Court also said that governments may come and governments may go, but we need to have a law which is fair, which is objective, and which is not open to misuse of the type we've been seeing, whether it's the case of those two girls in Mumbai, whether it's the case of the Tamil Nadu politician who criticized the son of the then finance minister, P. Chidambaram, or it's the case of the Standard 12 boy who just this month earlier was arrested by the UP police for posting objectionable content against Azam Khan, a UP cabinet minister. So, all of these instances, in a sense, coming together like a death knell for 66A, and the Supreme Court has very, very clearly said that from now on the local police, the men in khaki, will not have the power to decide what is objectionable and what is not. If at all a scenario like that is required, it will be done through a judicial order, is what the Supreme Court has said. However, Simi, we are awaiting the final written order of the court, which we are given to understand should be out after the lunch session. It's running into approximately 200 pages. So that will clarify a lot of things which right now remain in the realm of ambiguity. So we are awaiting that, and that's the scenario from the Supreme Court from now on, at least for now on. The pronouncement of the order has been completed more than an hour ago. Back to you.